Good morning, everybody. Thank you for joining this morning's webinar on employment law-related issues regarding reopening practices amid COVID-19. My name is Greg Buckler. I'm the Executive Director of the MSDA, and I'll be moderating this morning's webinar. We're pleased to have back with us Neal Serotte, Chris Feldenzer, and Anthony Herman from Serotte, Rockman Wescott, a labor and employment law firm in the Baltimore area, to address some of these issues. We were pleased to have this firm with us at the beginning of the pandemic, talking about some of the issues as we transition to the quarantine, and now that we're going back to work and reopening our practices. We're fortunate to have them back to talk about some of the issues about reopening. Just some housekeeping items. If you have any questions, please enter them into the Q&A tab along the toolbar at the bottom. We'll be able to capture your questions there for further follow-up. If you enter them into the chat, we will not be able to capture and save them. This morning's webinar is being recorded and will be posted to the MSDA website, hopefully later today, but possibly Tuesday after the holiday. So with that, I will turn it over to Neal and his team to begin. Thank you again for joining us.
Thank you, Greg. This is Neal Serotte. I'm not going to make a long introduction of the firm, but we are located in Towson. We have a practice that's limited pretty much to labor and employment law, primarily and almost exclusively representing employers. On occasion, we have represented individual dentists, but that's not what we normally do, especially where the law that's involved is somewhat unclear, as we are being confronted with that right now. As many of you know, because you probably have looked online, maybe have attended other webinars, the law that you're going to be familiar with as a result of this webinar is really changing almost daily in many instances. And so it is a moving target. And you have to remember that. We're going to be talking about the different areas of law, and frankly, that's going to be done almost exclusively by Chris Feldenzer and Anthony Herman. I'll be in the background and might throw a comment in every so often. But Tony, if you hit the next slide, as we've talked about before when we gave the webinar earlier, these materials and the information that we're providing is being provided for general informational purposes and summary and in a summary fashion. This is not legal advice. Frankly, we can't provide legal advice in this type of a forum. In order to really provide legal advice on any particular question, we'd have to know a heck of a lot more about the person asking the question. From an employer's perspective, we'd have to know a lot about that practice, any policies or employment practices or other practices, as well as the particular circumstance of any particular employee, whether it would be from the employer's perspective or the employee's perspective. All the details of any particular circumstance are very important in providing legal advice, and frankly, we can't do that in this sort of a forum. We have been sent by Greg some questions that people have posed. We have tried to include in these materials coverage of those areas, but we're not going to answer individual questions because frankly, we'd have to engage in fairly lengthy discussions with individuals and with the employers to find out what our best advice would be, which would be the application of judgment. So with all that said, we hope that what you learned today will alert you to the issues that you have to consider. And if the answer to any of your questions as you think about these things in opening or maintaining your practices anew, raise questions, you will seek further legal advice. We can provide that advice upon the establishment of an attorney-client relationship would take us entering into an individual agreement. But that's for another time. And we have done that with some of the members and with other dental practitioners over the past couple of months. So with that said, Tony, are you up at bat first or Chris?
I am Neal.
Okay.
And I'll take it away. So as Neal said, I'm Tony Herman, and let's get going. So we've kind of broken this down into two halves. I'll start off talking about some return to work considerations and issues as dentists and dental practices begin to think about bringing back their employees. And some big topics will be employee safety and recall and rehiring, some discrimination issues that might arise, and changes in employee benefits and compensation and issues to look out for there. And then in the second half of the program, Chris will discuss all the different issues that could arise if an employee refuses to return to work, which is probably the single biggest issue that employers are facing right now. So employee safety generally. I start off by highlighting here why employee safety should be every employer's biggest concern, and particularly in a healthcare setting like a dental office. And practically, of course, you want to keep your employees safe and healthy. I mean, that should be obvious to everybody. And you also want to alleviate employee fears about the return to the workplace. And Chris is going to discuss that more, but when employees raise concerns about returning to the workplace, their number one concern is going to be, I don't want to become ill, or because of their own concern or because of concerns about their families. So keeping your employees safe and implementing the proper safety protocol in the workplace will help alleviate that concern from a practical perspective. But from a legal perspective, of course, it's required under state and federal law. Under state law in particular, it's the Maryland Department of Health order issued just a couple weeks ago now, allowing, among other things, dental offices to open again to perform non-emergency procedures, provided, of course, that certain measures were in place, including, I guess, chief among them, that PPE that certain PPE was available. Now, besides the Maryland Department of Health order, of course, dental offices have to follow the guidance from the CDC and OSHA, and the most restrictive of such guidance is what you're going to want to follow. And this guidance is linked at the end of the presentation, and I can't get into the specifics of it all with you because that would be a multi-hour presentation in and of itself. And as Neal said, it's constantly changing almost every day. I understand from my research and looking at it from the ADA's perspective that for dentists, it may not be changing quickly enough, that there's a lot of push from the ADA for the CDC to issue new guidance from dental offices to as dental offices are reopening. One of the most common questions we've gotten ahead of this webinar is about the use and availability of respirators, for instance. At this stage, our understanding in dealing with other healthcare professionals is that N95 respirators have become more available. And so in procedures and in positions where they are required under the CDC and the OSHA guidelines, as I think Chris will discuss when he discusses OSHA, the bottom line is that as an employer, you're going to need to provide them. Of course, not everyone in the office is required to wear them. You're going to have to follow the guidelines, but as an employer, you can show that they are not available, and you can document that for certain positions and procedures. You may not need them, but for others, including as I know, for example, aerosol generating procedures, they're required no matter what. So the bottom line is that you have to follow these guidelines. Again, they are linked at the end of the presentation. These materials will be available, but I'm sure you are familiar with them already. Besides the specific guidance for dental practices, however, there's also CDC and OSHA precautions that all employers need to take, and some of these should be obvious, some maybe not so much. I've listed quite a few of them here. No shared social areas, that's break rooms you should take a look at. Maximize social distancing in the office, that kind of goes hand in hand with that. Increase deep cleaning and disinfection. Consider kick-in pool plates on doors. One-way traffic through the office. No shared equipment that may go on in dental offices already. Make efforts to increase air exchange in building. That's considered engineering control under OSHA. Consider temperature checks and employee screening. While not required, that is heavily recommended by the CDC, and I'll talk more about that in a minute. Restrict non-essential travel. And perhaps the biggest thing is to document and train employees on these issues. If you receive an OSHA complaint, you can do all of these things, but unless you can prove that you have implemented these controls in your office, you won't be able to defend your practice that you have taken the proper safety precautions. So let's say that you are now screening employees as they enter the workplace and that you are taking their temperatures. You used to not be able to do that, but the EEOC has said that you are now able to do so under the ADA. There's a lot of issues that go along with that. If an employee is taking other employees' temperatures as they enter the workplace, you have to consider the safety of the employee taking other employees' temperatures. Are they wearing the proper PPE? You have to consider the thermometer being used. It's recommended that you use a touchless infrared thermometer, but if you're not, you have to consider disinfecting that thermometer after every use. And if you are, how is the training going to go for the use of that thermometer? FLSA issues. That is that if you're not allowing employees to enter the workplace until they are screened for temperatures, are you paying employees for the time that they spend waiting? Social distancing and safety. Again, if employees are not allowed into the workplace until they are screened, how are you making sure that employees are being safe while they wait to enter the workplace? What about employees who cannot have their temperature taken for some reason, or employees who may be running a fever for non-COVID-19 related reasons? Are you required to reasonably accommodate them? These are all issues that you may need to resolve. Other issues with safety, other safety issues and screening. under the ADA, employee health conditions, including their medical symptoms and their temperatures, must be kept confidential. However, at the same time, if God forbid you do have an exposure in your workplace to COVID-19, other employees must be advised that there was a workplace exposure. Well, that doesn't wipe out the prior bullet that that employee symptoms and temperatures must be kept confidential. So, but yet the last bullet, you must contact your local health district about confirmed COVID-19 cases or exposure. Now, it's been our experience that they will, that the local health district will take care of a lot of the contact tracing for you, but it's quite a delicate juggling act that an employer must undergo if, again, God forbid, that you have to deal with a situation where an employee tests positive for COVID-19. So, as I mentioned at the top, potential discrimination claims could be some of the most expected litigious areas going forward as employers recall and rehire employees that were laid off or furloughed. If you attended our previous webinar at the beginning of the COVID-19 crisis, you'll remember that we warned about the dangers of discrimination and retaliation in the RIF, that's reduction in force, and layoff context. Well, the same risks apply in rehire context, but they might be even more heightened in bringing employees back, because often we found that, unfortunately, in the RIF or shutdown context, employers had to lay off maybe their entire staff, or at least most of it, and we're finding that employers now are bringing back some of their employees at a time. And if, as an employer, you do not bring your employees back on a legitimate, non-discriminatory basis, you could easily have a claim that you didn't, so that is that you made your decision on a protected basis. The first thing you want to look at is whether you made any commitments when employees were laid off originally. So you should be consistent with past promises. However, again, your decisions could form the basis of a discrimination or retaliation claim. And retaliation could be on any number of bases. It could be under the FFCRA even, which Chris will discuss, whether the employee made any complaints under the FLSA, under any number of state or federal statutes. And under the last bullet, again, you must be prepared to explain in writing with documentation what your legitimate non-discriminatory reasons for who comes back and in what order are. Tenure always works. That's that's what we say. Tenure always works. So a question that we get asked a lot is that it is a good reason that you, as an employer, if an employee falls into an elevated risk category for the CDC guidelines, is that a legitimate basis not to immediately bring him or her back? And the answer, quite simply, is no. That could be a violation of the ADEA, the Age Discrimination in Employment Act, or the ADA, the Americans with Disabilities Act. And age claims under the ADEA, or what's called regarded as claims under the ADA, they're possible when determining whether to recall employees. And that's because under those laws, you can't make the decision for employees that you're acting in their that you're acting in the employee's self-interest when deciding not to bring them back. And the EEOC has put out numerous guidance materials on this, and they've said specifically that with regards to possibly disabled employees, employees who may fall into an elevated risk category because they have some form of disability, that that you need to assess whether their disability poses, and this is a legal term of art, a direct threat to his or her health that cannot be eliminated or reduced by another legal term here, a reasonable accommodation. And that is a very high burden to clear. So if you do, as you are bringing employees back, what about changes to their benefits and or compensation? A lot of practices have suffered big financial hits and may not be able to pay employees the same kind of benefits and compensation that they were paid before. Well, for employee benefit issues, I'll just say right up front that if you are considering any changes to your employee benefits, you're going to need to review this with your benefit counsel. But some things to keep in mind, to keep an eye out for, rather. Your health plans. Determine whether employees returning to work will need to re-enroll or whether you need to update prior plan elections. What about employees working part-time now? Will they still be covered under health insurance? Evaluate whether returning employees owe any portion of healthcare premiums while furloughed. If they do, you cannot just automatically make deductions from their pay. There is a Maryland law regarding wage deductions. You're going to need to seek counsel in order to accomplish that. Pension or retirement plans. You need to review them with counsel and consider whether there has been a break in service and what implications that may entail. Also, evaluate potential need for plan amendments to modify conditions for annual benefit allocations. Again, these are very tricky stuff to review with a ERISA benefit counsel. Now, employee compensation and pay issues. If there were any changes in compensation made during the downturn, or whether you want to change employee pay prospectively, or whether you have bonus plans in your practice that you are now going to alter. The FLSA and the Maryland Wage Payment and Collection Law may be implicated, will be implicated, I should say, and those laws come with heavy damages, as in cost up to 3 times the amount of liability, plus attorney's fees if they are violated. So consider the following issues. Again, discrimination and retaliation claims. It's the same issue as recalling and rehiring employees that I was discussing. So who are you making the decision to change the salary of? If you're not doing that on a legitimate, non-discriminatory basis, you could have a big claim there. Maryland has a law requiring advance notice of a decrease in salary. Could have a claim under the Maryland Wage Payment and Collection Law. We talked in our previous presentation about the white-collar exemptions for executives, administratives, and professionals requiring a specific minimum salary. That's up to $684 a week now. And also under that exemption, any week in which an employee performs any work, the employee must be paid the entire week. So you want to look out for that to make sure that the employee maintains a salary basis. If those concepts are not immediately familiar to you. You'll want to seek counsel on that. Perhaps one of the biggest issues, employment contract issues. We've run into this a lot. It's not easy, almost impossible to reduce employee pay under employment contracts. Unless there is a force majeure clause in the employee contract, you may not be able to do so. You're going to want to review that with an employment counsel. It can be very, very difficult, and it's something that's, again, going to be heavily litigated in the months to come. Other wage and hour issues that may arise that may not be so obvious. Claims arising out of time spent associated with the safety procedures discussed at the top. Again, if you're doing temperature checks, what about if you require employees to don personal protective equipment right at the beginning of their shift? That time would be compensable. Work from home reimbursements if you've had employees working from home. Cell phone, Wi-Fi, office supplies, etc. There's a question on the compensability of those expenses, especially if the employee is close to minimum wage. There could be a wage issue there. All of these may need to be reviewed. So with all that being said, as employees come back to work, it's generally our advice and the advice of others to consider a return to work letter for employees. In such a letter, you would offer employees, their employment back and set a return to work date, and update the terms and conditions of, their employment. Obviously, you would want to reaffirm their at-will status. That's very important. Any changes to the wage and hours that we discussed, and their benefit status, how you express that, obviously, would be crucially important. And probably the biggest thing is to outline the safety procedures that the office has undergone, and alleviate those fears, and set forth what the office is doing to ensure a safe working environment going forward. So now Chris is going to take it away, talk about what happens when an employee says, I'm not so sure about this, and what kind of issues could arise there.
Hi, I'm Chris Feldenzer. As Tony said, I want to talk a little more in depth about one of the main problems that any employers, including dentists, are likely to have, which is there are two scenarios we foresee, or you may have already experienced if you reopen. You have the employee who refuses to return to work following a layoff or the practice closure, and then you have the second scenario where an employee has already returned to work, but they are balking at a particular assignment because of COVID-19 related issues. I mean, this can take the form of, somebody in your front office who doesn't want to greet patients as they come in, or your hygienist that doesn't want to work with a particular procedure. There's a whole host of issues here. And as Tony said, some of these may be allayed by the fact that if you reopen with training, as practices should do, you address these at the outset. So there is not it doesn't come up while you're treating a patient or dealing with a particular procedure. So with that said, there are four basic reasons that may underlie an employee refusal to work. One is, there's specific concerns, safety issue concerns in the workplace. Two, as Tony touched upon, there are employees who will have health risks, increased health risks, based on some underlying condition, medical condition, or age. 3, there are employees who have child care issues that are preventing them from returning to work or requiring that they have modified schedules. And 4, there are employees who have been receiving unemployment benefits and simply don't want to return to work for one of the above reasons, or simply they're enjoying collecting unemployment benefits. So scenario 1 is the employee with specific concerns about safety issues in the workplace. And those typically are going to take the form of, some inadequate personal protective equipment, no face shields, not the adequate level of respirator mask or insufficient gowns, a whole host of issues again there. As Tony said, those you're going to have to follow as closely as possible the State Department of Health guidelines, in terms of how much PPE you're required to have on hand, the CDC guidelines about how often you have to change this protective equipment. Another issue is workstation configuration. Some of your offices may have separate open offices where the chairs are only separated by a half wall. Some of them may have actual separate offices. And then you have the issue of patients you're treating who, for one reason or another, an employee feels that that individual may have COVID-19. And some of this should be handled by, you're going to screen patients ahead of time, presumably, and you should avoid most of these with the training at the outset of reopening your practice, surveying of patients. A lot of this should not present itself in the workplace, but it may. And if there are safety issues, I mean, like any issue, I think the way to handle them is as an employer, we advise clients, you want to treat employees with respect, take their complaint seriously, and address it as best you can in the present. And if there's follow-up needed, deal with that. If you need advice of counsel, talk to counsel. You don't want to put up a wall and say, we're not doing that, or belittle their safety concern at this point. There's a whole spectrum of people out there, whether we're talking about employees or patients, that have different fear levels about this. So you may have an employee who's greatly concerned about their health for whatever reason. They may be young with no impairments, but they have grave concerns about getting infected with this and dying. So keep that in mind when you deal with your employees. The standards that we've talked about, there are specific PPE. We're not going to spend time talking in this webinar about what level of PPE you must engage in. Just know that there are OSHA standards out there for PPE requiring gloves, eye and face protection, respiratory protection. If you're using a respirator like an N95, the OSHA regulations require respiratory protection programs. What's the source of this duty to maintain a safe workplace? Well, we have a general duty clause in the 1970 Occupational Safety and Health Act that's been around for 50 years. Requires employers to furnish each worker with employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm. So that's the hook for an employee to challenge some safety concern in the federal law. There are other OSHA standards that you may be familiar with in your or should be familiar with in your practice, the bloodborne pathogen standard that you're already complying with. And keep in mind that Maryland is one of 28 states that operates its own safety and health program under the auspices of the federal OSHA, and it's called MOSH. And just be aware that's who you'd likely be dealing with if somebody registered a complaint about one of these issues. Kind of the legal standards behind this and the legal issues that are raised. Generally speaking, an employee does not have a right to refuse to work unless there's some reasonable apprehension of death and serious injury. So the questions are, you know, if you're addressing this with your legal counsel, is the employee's refusal to work a good faith refusal with no other reasonable alternative available? Is the working condition such that the employee believes it to be of such a dangerous nature that a reasonable person under the same circumstances then confronting the employee would conclude there is a real danger of death or serious injury? Keep in mind, this is an objective standard. It's not what that particular employee believes. It's not a subjective view of the employee. It's what we say in the law a reasonable person would understand from that particular condition, working condition. Other issues, is it such an urgent situation that there's insufficient time to eliminate the hazard through the use of OSHA's regular enforcement mechanism? Has the employee requested from the employer and yet been unable to obtain a correction of the dangerous condition? If somebody points, if one of your employees points out this condition, you're best advised to address it and not put it off, and document what you've done to address that concern, whether it's consult guidance or take some action to alleviate or mitigate the risk in a particular procedure or design of the office. And again, you're as Tony said, you're going to point to the guidance from the CDC and OSH available at the federal level, and anything the Maryland Department of Health issues, which are, as he said, evolving on a day-to-day basis. So you're going to have to keep aware of those standards on an ongoing basis. Okay, the second scenario, which Tony also touched upon, is you have an employee's own increased health risks from COVID-19 based on their medical conditions or age. With regard to the age, I think he addressed that. You know, employees have protections under the Federal Age Discrimination in Employment Act and also under the state Commission on Civil Rights. There's a similar human relations law at the state level. Applies to employers with 15 or more employees. So if your practice has that many, if your practice is small enough, you know, under 15 employees, you still may have issues because there are local human relations commissions. Montgomery County's Human Relations Commission has jurisdiction over employers that only have one employee. So you're not out of the woods simply because you're a small practice. Keep in mind on the EEOC guidance says that with regard to disabilities, which can be physical or mental impairments, unless the employee voluntarily discloses that he or she has a specific condition or disability that places them at risk, you may not make such disability-related inquiries or require medical inquiries. So the employee's got to raise their hand, or you can make these inquiries in a kind of roundabout way, as many do on employment applications, that, you know, if anybody has a condition that they need an accommodation for, you know, you're invited to let us know. You can't do more than that. So if somebody's hiding something they don't want you to know, Your duty as an employer is not to search that out and find out what it is. Also, the mental health impairments, employers may disregard this. There are people with specific mental impairments that, whether it's an anxiety disorder or a post-traumatic stress disorder, which may exacerbate their fears related to this pandemic. The EEOC has said, and the general guidance out there is that a generalized fear is not sufficient to form a disability that must be accommodated. So somebody's just, your average employee just, has a fear about this. That's not sufficient. I'm not saying you should disregard it, but it's likely not going to be a disability or an impairment that you're obligated to accommodate to the extent you could accommodate that. I think we've already addressed the sources of these legal standards are the Americans with Disabilities Act. The agencies that enforce these laws are the EEOC at the federal level, Maryland Commission on Civil Rights at the state level, and to the extent your county or jurisdiction has a local human relations law, you're obliged to follow that. And those local laws may be even broader than, or are likely to be broader than the federal law in certain jurisdictions. So in analyzing one of these issues is, does the employee have an impairment, physical or mental, that may be considered a disability under the law? Many years ago, when the ADA came into existence in 1990, there were great legal fights over whether somebody was disabled or not. Since the act was amended in the early 2000s, that legal issue has kind of gone away as far as litigating whether somebody truly has an impairment that rises to the level of disability. Typically, employers move on to the employment counsel tell employers to move on to the issue of what's the obligation to accommodate this issue. The employee doesn't have to use some magic words. If they requested an accommodation or some assistance in performing the essential functions of their job, you're obligated to engage in what is called in the law an interactive process. That is a give and take discussion between the employer and the employee as to what accommodation is reasonable. You're not obliged to take the employee's suggested accommodation. It's just you're obligated to provide a reasonable accommodation, not the reasonable accommodation they're demanding. So typically, let me give you an example. The employee may say, well, I want to telework. I want to work from home. Well, obviously, if you're a dental assistant or a hygienist, your job cannot be accomplished from home. There may be an issue with an office manager or a scheduler where you're obligated to consider in certain circumstances whether they can accomplish that work at home. Obviously, you got to have a greeter, somebody in the office to bring patients in, or if there's billing requirements at the time the patient's services are finished, you'd have to have somebody there to do that. So there may not be scenarios where you can do this. One legal risk is associated with these disability considerations is whether the employer has failed to consider a reasonable accommodation. So you can have legal risk or jeopardy just by your failure to consider a reasonable accommodation. That's why it's so important to engage in this interactive process. The other issue is, and I think Tony touched upon this as well, are you treating that employee with a disability differently than similarly situated non-disabled employees? Whether that's excluding them from the workplace because you think that they're at risk. You'd have to go through this direct threat standard analysis that Tony talked about, and that's one where you want to talk to employment counsel before you engage in something like that. But again, it's a discrimination analysis. You're treating one employee differently than a similarly situated employee who's not disabled. Okay. The third scenario brings up leave-related issues that are I assume, very prevalent in most dental offices. Whether you're assistants or your dentists or your hygienists or your office staff have child care issues related to this pandemic. School is closed, and that was their daycare. And that will end soon, but the issue is likely not to go away because many summer programs and camps that parents typically use for child care will not be operating this summer. So that's the factual scenario. The leave that's available, since the Families First Coronavirus Response Act, which became effective April 1st, 2020, and sunsets on December 31st, 2020, provides paid sick leave, 10 days, for a reason that's associated with child care. And then there's, in that same act, there was also what's called the Emergency Family and Medical Leave Expansion Act. That also provides, typically most dental practices are likely under 50 employees and weren't covered by the FMLA. They would be covered, they may be covered under the these two pieces of the FFCRA. Whether they are or not remains an open question. We haven't seen, well, let me just cover, we covered this in the prior webinar, but this is what we're talking about. Under the Emergency Paid Sick Leave Act, an employee could receive up to 2 weeks, 80 hours if they're a full-time employee, or the part-time employee's 2-week equivalent of paid sick leave at 100% for the qualifying reasons, including child care, and 2/3 for certain qualifying reasons related to care for others, up to $200 a day. And on the FMLA Extension Act, if you will, which covers employers down to one employee, they could get up to 12 weeks of paid sick leave and expanded family medical leave paid at 2/3 for child care reasons, and the cap is $200 daily. Eligible employees, this is right out of the notice that the Labor Department put out for the FFCRA. Employers with fewer than 500 employees are covered. Employees who have been employed for at least 30 days are eligible. Under the standard Family Medical Leave Act that came into existence back in 1993, you had to be employed for a full year before you were eligible. Under this law, only 30 days. So keep that in mind. Now, the threshold legal question is, the $64,000 question, as they say, is, does this apply to my dental practice? Now, there's two possible exemptions. One is, the exception number one is, you have less than 50 employees, and you can establish that providing such benefits would, quote, jeopardize the viability of the business as a going concern. In the regulations, they set out in detail what you would be, kind of three disjunctive requirements that you would have to establish and document. An authorized officer of your practice would have to document. One is that providing the leave would result in expenses and financial obligations exceeding available business revenues and cause the practice to cease operating at a minimal capacity. These are going to require a lot of in-depth financial examination on your part to establish. The second criteria that you may be able to utilize is the absence of the employee or employees requesting the leave would entail a substantial risk, again, to the financial, health, or operational capabilities of the business because of their specialized skills, knowledge of the business, or responsibilities. And the last one is there aren't sufficient workers who are able, willing, and qualified who would be available at the time and place needed to perform the labor or services provided by the employees requesting leave. And these labor services are needed for the business to operate at a minimal capacity. So it's going to be a heavy lift to establish this financially. The second exception, which may be available or may likely be available from what we've seen, but there's been no official guidance on this, is the dental practice and its staff considered healthcare? Are they considered healthcare providers within the meaning of the FFCRA? When the initial statute came out, there was very little in the statute itself to suggest that this was going to be broadly defined. But in the DOL's temporary regulations, as I have on the slide, anyone employed at a doctor's office, hospital, healthcare center, clinic, et cetera, et cetera. So there were people who have been defined as healthcare providers that are working at facilities that produce medical equipment or labs that have no contact with patients. That would be the argument that your dental practice is considered and staff are considered healthcare providers. Has that been resolved yet? No. Is there a risk in asserting that exception? Yes. What's the extent of that risk? It's hard to say at this particular point. As Neal and Tony and I have discussed, the ADA has not taken a particular position on this yet for whatever reason, and we haven't seen anything from the Department of Labor or anyone else suggesting that they're in or out. There are other healthcare professionals, whether they're optometrists or podiatrists, that have asserted that they're entitled to this healthcare provider exception, but there is risk with asserting it. So before you go down that road, our suggestion is talk to your counsel about whether they think the exception is available for your practice, and determine what the latest guidance on it is. Okay. Just quickly, the legal risks with asserting or denying leave under these statutes. There are in the statute prohibited acts. If you discharge an employee, discipline or discriminate against them because they've taken leave or engaged in legally protected activity under the Act, you can be liable for damages, including liquidated damages, which are double the back pay. Under the Extended Family Medical Leave Act, which would necessarily involve child care issues. If it's applicable, you have risk if you interfere with or discourage the employee's exercise or use of that. Again, we're talking about back pay and attorney's fees and liquidated damages. If you discriminate or retaliate against an employee for exercising or attempting to exercise those rights, if you grant the leave and you use it as a negative factor in subsequent employment actions, such as promotions or disciplinary actions or bonuses, et cetera, you can incur liability from that aspect as well. And if you're using a no fault attendance policy and you permit employees to utilize this leave, it should not be counted under your no fault attendance policy. It's protected leave. Okay, the last scenario is, which may be quite common out there right now. I suspect by the end of July this issue will die away, is the issue of unemployment benefits. Right now, employees who are on unemployment are receiving this extra $600 per week, and it has operated in some circumstances as a disincentive for employees to return to work. If a claimant, under Maryland unemployment law, a claimant may be disqualified from receiving unemployment benefits if he or she voluntarily quits her employment. The operative term there is voluntarily. There are two exceptions that are may be operational here to that, and may provide that where they may be able to continue benefits, or if they weren't receiving benefits, to receive benefits with only a minor delay. One is what's known as the good cause exception, and the other is the valid circumstances exception. The good cause is one that is attributable to, arising from, or connected with the conditions of employment or actions of the employer. You know, there's a scenario out there, I'm sure, where an employer or a practice, let's say, refuses to take any actions with regard to mitigating risks in the workplace, and you say, I have health conditions, they won't do anything the practice won't do anything to mitigate the risks, my health risks, I'm quitting. But I have good cause because the employer was so indifferent as to the health risks here. The second scenario, and I'm moving quickly through this to get this in, is what's known as valid circumstances. That is, the employer has done everything they're obligated to do. You've made your practice as safe as possible. You're following all the guidelines, and the employee still says, you know, I've got these health conditions that you know, I can't work in the current circumstances at a dental office with these conditions that I have, whether they're immunological conditions, but some physical or mental impairment that prohibits them from working. They could claim that that's a valid circumstance for them to quit and may be eligible for benefits. Is there any law yet in this area from the Maryland Department of Labor Division of Unemployment Benefits? None that I'm aware of, but you know, analogies can be made to past cases involving health conditions. So be aware that it's not a slam dunk that if somebody quits or refuses to return to work, they're going to be disqualified from unemployment benefits. And of course, the legal risk, or one of the legal risks associated with that, is you would absorb a increased experience rate for your unemployment taxes in subsequent years. A couple of other quick issues that I wanted to mention before closing is, if there are complaints from employees about safety issues, and the employee is complaining on behalf of coworkers or is complaining with coworkers, there is an issue under the National Labor Relations Act that they are protected, and they're protected by a portion of the statute that says protected employees who engage in protected concerted activity, that is concerted meaning together, about working conditions, are afforded the protections of the National Labor Relations Act, which would mean if you discipline them or discharge them, you could be liable for back pay with interest. So if you have reason to believe that an employee is not acting alone, and is complaining on behalf of other employees, just keep that in mind. There's a risk there under the National Labor Relations Act. Most employees are not aware of that law if they're not in a unionized environment, but it does protect those employees regardless of whether they are involved with a labor organization. The last issue is there is state law or state statute that makes it unlawful for a public or private employer to discharge an employee who is under an order of isolation or quarantine or because of such order. Now, order has a specific meaning in that law. If you discharge somebody, they could file a wrongful discharge action against you. Just be aware of that issue. If an employee says, or they, let's say there's some hotspot pops up and the governor or the county executive says everybody in that area is quarantined. Let's say it's 3 months from now. If you discharge them, you could have liability on a tort claim under state law for wrongful discharge. Okay, Tony, you were going to...
Yeah, I know we're a couple minutes past here, but if you'll indulge me one more minute, I think about every employer on this call is going to face this last issue. It's a very common scenario. So you furloughed employees, and during that furlough, you've required your employees to use all of their accrued PTO. But now employees come back, but they need to take time off. What do? Your first instinct, I'm sure, may be to say, hey, they used all of their accrued PTO for the year. I'm not letting them take any more time off. Well, there's no one-size-fits-all answer, and you may need to consult counsel. There's lots of considerations. The reason for the leave being chief among them. There may be different state or federal laws that apply, whether it's the Americans with Disabilities Act, whether it's the FFCRA that Chris discussed, whether it's Maryland law, the Maryland Healthy Working Families Act. You certainly need to consider your PTO policy, your past practice in that regard. I stuck it at the end here because obviously, it's not an issue with bringing employees back. It's once employees are already back, but it's definitely something to keep an eye out for going forward. So I just wanted to conclude with that. As I said, some of the resources, these are, I think, exclusively safety related. They're for your consideration here at the end. And I understand from Greg that this will be linked somewhere on the MSDA website. I'm sorry we took a little longer than anticipated. It's only 10:05, didn't do too bad. But I thank everybody for their time sticking with us. Our contact information here is at the end of the program as well.
Thank you, guys. We will post this on our website, and many of those resources are already listed on the MSDA's COVID page. I know we're a couple minutes over, but there are just a couple questions I think kind of can be answered quick if I can just read through them and we can take a second. Question about hazard pay in addition to salary and false workman's comp claims. Have you seen or heard any of this that you can quickly address?
What was the second part of that? False? What?
The question says they should have disability or there may have false workman's comp claims.
This is Neal Serotte. There is a standard under workers' comp where somebody submits a fraudulent claim, but it's very, very, very hard to prove. And I will tell you that the Workers' Comp Commission will bend over backwards not to find that there was a fraudulent claim because they don't want to dissuade people from filing claims. If it's a bad claim, then it will be denied. So I think that that's the answer as far as that's concerned. What was the other question, real quick?
Hazard pay?
Oh, hazard pay. Some employers are considering doing that to provide an incentive for people to come back. There is no statute, federal or state, that I'm aware of that requires hazard pay. Certainly, there's nothing in Maryland. And so that would be something for the employer to consider, as Tony said, if they were going to make a change in the compensation arrangement. Of course, if that was to provide more pay, there is no waiting period under the Maryland Wage Payment and Collection Law, as there is for a reduction in pay.
You've already commented about the back to work orders of May 6th from the Department of Health requiring dental practices to provide N95 respirators. What if in their good faith they purchased these respirators and masks, but turned out that some of the KN95s are counterfeit or not what hold up to the standard that is necessary? Is there any benefit or course that the practice can take?
I think it's going to come down to whether or not they can make reasonable efforts to get legitimate N95 masks. If they're not available, then obviously under the regulations, CDC and OSHA guidance, they're told to what alternatives are available. But if it's an aerolizing producing procedure, the guidance is much more strict. And if you can't use N95s, there are PAPR type respirators that might be appropriate, whether they're available or not available. So I think it's going to depend upon the availability. Frankly, I think there was some issue that the CDC and or OSHA confronted when masks were so short supplied that they permitted masks to be distributed even when they were not completely checked out by the FDA. But I think that since that's now gone by, it's going to be, I think, the burden on the dental practice to show that they can't acquire these masks. I know there'll be an additional expense, but I don't think that that's going to get you off the hook without some concerted effort made to get appropriate masks.
Two sort of related questions. One is about an employee who says they cannot return to work because they don't have daycare. The employer identified available options, but they're refusing that. And another is talking about an employee who says they are not able to return to work because they have to stay at home to teach their children because of the distance learning that's going on.
Yeah, all that is going to depend upon the particular facts and circumstances and the choices made by the employer with regard to the FFCRA. As Chris said towards the end, those employees may well be entitled to unemployment insurance if they're not, if the employer doesn't provide FFCRA, makes that decision. So we can't give some generalized advice on that. It's going to depend upon the particular facts and circumstances of the employment situation, and as well as the employee's particular situation.
Can an employer drastically change an employee's work hours and expect them to work that without objection?
An employer can change, unless there's a contract, an employer can change conditions of employment on a prospective basis. If they change this condition so significantly, the employee may be able to consider that a constructive discharge, and they may be entitled to unemployment benefits. They may be able to say, I will not work under those conditions. You've changed my job so much that it's a different job. Therefore, it amounts to a discharge. And again, the employee may be able to get unemployment based upon a quit for good cause.
Right.
If a household member is quarantined due to a positive test and exposure, what is the responsibility of the employer and the employee?
Well, we've talked about that in some general terms. Again, it's going to depend upon the particular facts and circumstances as to whether or not the employer has to take that into account under the CDC guidelines, and as well as the law like the FFCRA. But it's going to be factually dependent upon the nature of the supposed health impairment of the family member, the nature of the job, whether it's been diagnosed by a physician, and whether the physician says that this is necessary that the person be quarantined. So there's too many factors to give it a blanket answer. But most employment lawyers are saying that employers should be empathetic, but that they don't have to necessarily in all circumstances permit the employee to be off or be entitled to FFCRA benefits if the employer is going to provide them in this circumstance, is considering the exemptions that may be available. So there's no one size fits all answer.
I think you already addressed this one. You talked about the ability to screen and take temperatures of office staff. Does that include additional screening and enhanced screening for new employees that you're thinking of bringing on?
Well, there can be medical screening, but the ADA generally restricts how much medical screening an employer can do pre-hire before a conditional offer of hire is done. Now, the EEOC has said that temperature screening can be done, that there are certain inquiries that can be made with regard to COVID symptoms and COVID, diagnosed conditions, but that does not give an employer open season to ask all nature of questions. Certainly before hire, just like they couldn't ask those questions after an employee is hired. Generally, under the ADA, an employer is very, very restricted from asking employees medical questions, making medical inquiries, or requiring an employee to be tested. There are very strict limitations on that, but the EEOC has permitted some of these inquiries directly related to COVID. Also, pre-employment inquiries after a conditional offer of hire, they have to be supported by business necessity, have to be job related and supported by, which means that the medical conditions about which you're making inquiry have to be connected with the performance of the job. You just can't ask any medical question. You can't do generalized medical inquiries necessarily. You may be able to do broader, if you do a broad medical examination, which may actually be permitted, you run the risk that you're using information that you found that is not tied to the performance of the job. And if you don't hire that person at that point, an employer runs more risk. So while generally you may be able to do a general exam, it's heavily advised not to do so unless the information you're obtaining can be tied to the performance of the essential functions of the job.
As a follow-up to that, can a dental office that's hiring an employee request to see a doctor's note from that employee to see if they were really seen and evaluated?
I'm not exactly sure whether there was some question, whether there was a circumstance where the prospective employer had some inkling that the employee may be unwell with regard to COVID. If there was some information that was supplied that said that the employee may have been diagnosed with COVID, the employer may be able to ask for some information. But though the advice that it's come out from these agencies is that doctors are so busy dealing with COVID that any extensive information from a doctor is not going to be permitted. That it really is just going to be, in general, some statement that the employee is fit to work.
An employee originally said they were taking unpaid leave, but then later applied for unemployment. When they return to work, they're refusing to come for an additional week. Must they take accrued leave?
Again, this is going to be very factual intensive.
Okay.
So can't give a generalized answer. It depends upon the policies, practices of the employer, and all the circumstances, medical or otherwise, that the employee has been subjected to or has present.
An employee refuses work and is getting unemployment. What is the employer's responsibilities and notification to Maryland Unemployment that they were offered a position but refused to come back?
There is an email address that the Maryland Department of Labor Division of Unemployment has, where if an employer has offered employment, that they can notify the department that this employee who is on unemployment has been offered the job. So that's the mechanism that we've been able to find, and that's been in existence, frankly. It's on the Department of Labor's website. There's a manual for employers that has that website address, or that email address. As I think Chris said, there are ways for an employee to nonetheless be entitled to unemployment because of good cause or valid circumstances. So just because they've been offered a job, their circumstances and the circumstances of the employer may produce a situation where they are nonetheless entitled to unemployment. Now, what Chris didn't mention is that if there's good cause, almost all the time that unemployment benefit, at least the state portion of the unemployment benefit, is going to be calculated into the employer's experience rate. If it's valid circumstances, which really don't have anything to do with the employer, then the employee may be entitled to unemployment, but it will not be charged to the employer's experience. The $600 unemployment, by the way, it should not be charged to the employee. That is federally funded, as is, I believe, the additional 13 weeks of unemployment benefits that may be available pursuant to the CARES Act.
Questions are continuing to come in, but in the interest of time, we'll stop here for now. I'll send Neal and his team these additional questions to see if they can provide a general comment, and we'll post those responses with the webinar on our website. Any final comments, Neal, Chris, or Tony, before we?
Again, all I'm going to say and repeat what you've already heard, and as you can see by some of my responses, this is going to, these issues really require an individualized review. These general principles certainly are going to apply in some way, but frankly, when you put some of these factors together, the juxtaposition of these various laws sometimes make it very difficult. There is no bright line test for most of this stuff. Workers' comp, ADA, FMLA, this expanded FMLA, they all touch, for instance, on the same circumstance. Workers' comp is now kind of, not workers' comp, unemployment comp has come into the picture as an additional factor. So we think it's important that dentists and dental practices are aware of all these issues, and that it's not simple in making determinations when employees raise issues, and that frankly, unless it's real straightforward, which most of this isn't, they really have to consult somebody who's knowledgeable in how all these laws come together.
Very good. Well, thank you, Neal, Chris, and Tony, for your time and assistance with some of this. Again, we will make this available. As a final comment, there appear to be some questions that were asked in the chat. A reminder, I'll keep this open just a few minutes longer once we end. If you typed a question in the chat, please type it in the Q&A section so we can pick it up at the end when we close out the webinar, and we'll be able to address it. Questions that were answered in the chat will not be retained. So thank you all again. This will conclude this morning's webinar, and have a great day.
Thank you.
Thank you.